meeting of the zoning. Thank you. This is a regular meeting of the zoning board of appeals of the town of Orleans. It's been properly posted, and there are two items on the agenda. Present are the following: the building commissioner of the town of Orleans, Thomas Evers, also members Michael Marnick, myself, and members as chair, and members Matthew Cole, Gerald Mulligan, vice chair, Lynn Eckholt, and Bruce Taub. We do have a quorum, and there are two items on the agenda. Case number 2172 was noticed first on the agenda, and that is the application of David Currier on behalf of owner A.J. Luke of the premises at 14 Lots Hollow Road for special permit in accordance with General Laws, Chapter 48, Section 6, and zoning bylaw 16444, and that is also 16440.40.4 of the zoning bylaw relative to marijuana establishments. The present use of the building is office space and apartments, and the applicant proposes to continue the apartment use and also settle in a retail cannabis shop. The applicant noted that the planning board has passed on this application, and we have received separately from the town planner the site plan review. I'll look for the date of it. Anyway, we received that as well. Now, it was brought to my attention this afternoon that 160 bylaw section 164-40.4E2 requires, in connection with the processing of a special permit application, that any licenses and permits be part of the application. Mr. Meservey noted that, as far as he knew, that the town had not received those documents with the application. I have reviewed the application, which has been filed in case number 2172, and it doesn't have copies of any permits. It does address itself to the categories and requirements of 164 section 44 special permit, but there's an overlay here, and we don't have that, and I'm asking whether the applicant has any comment on how we deal with this. In other words, it might be premature. Mr. McNamara.
Thank you, Mr. Chairman. Yes, so we received the same email today. The planner stated, as you had indicated, we would have been comfortable proceeding with the ZBA with the state license as a contingent or as a condition on the special permit. However, if the process that the board is to follow is the one recommended by Mr. Meservey, in other words, that we should somehow receive a provisional license from the state before we proceed with this board, then we're willing to accept that result. And in that instance, we would request to postpone or withdraw the hearing today.
You don't want to withdraw the application. You want.
No, we would not want to withdraw the
You
application.
postpone the hearing, which would, as a general rule, the zoning board of appeals is the last stop on the railroad. And in this case, 164-44E2 does make it a prerequisite, a condition preceding that any underlying licenses or permits be attached to the application. So, and that would mean that what we're doing tonight wouldn't be moot for some other reason. In other words, we would like to wrap everything up and have a full hearing, knowing that once we finish our business and file a decision, then you may proceed in the usual fashion. So that was my thinking. I could ask for any comments from the board. My thinking is that ought to be a ruling right from the chair. If you need time and let us know now if you can. Let the record reflect that Emily Van Giesen, a member of the zoning board, has joined the meeting. If you have an idea how long that might take you.
As to the application, we have all of the materials prepared, ready to submit. The state's process, just for context, is there's a few steps. So when we submit the application, they will inevitably issue an RFI. After that process is complete, we would get what's called a provisional license. And I believe that is what Mr. Meservey must be looking for, because beyond that, we would need all town approvals in place to proceed for a final license.
Look to me that all the other requisite town approvals here in Orleans, they're done. Is that
Correct.
right? And
That's
then
my
the special-
understanding.
And then the special permit for the use.
Yeah.
And under 164 44. So what we need from you is a motion to continue to a certain date. And if you could confirm that with an email to the board secretary, that would be great. Can you give us a date now?
Can we request 30 days?
That would be fine. So that we have May 18th, first week in June. We hear on every 2 weeks starting the first and third Wednesdays of every month.
Okay. I would say maybe okay, first and third Wednesdays. What about the 15th of June? Would that be okay?
It's fine with me. Members of the board, anyone have any comments on what's happening here? Then let it be so. Members of the board, we have a motion by the applicant to postpone the hearing for the filing of copies of any requisite underlying state licenses and permits till the first meeting in June.
Mr. Chair, I apologize. I believe that would be the second meeting in June.
Okay, the second meeting in June. Excuse me. Then
I'll make a motion that we continue the hearing until June 15th.
is there
Second.
the second by Mr. Mulligan? All those in favor?
Aye.
Aye.
By acclamation, aye, the motion carries unanimously. The hearing on case number 2172 is continued till June 15th, 2022.
Thank you.
Thank you, Mr. McNamara. Thank you, members of the board. in order, and continued from April 20, 2022, is the hearing in case number 2171, which is the application of Philip Ruggieri for a special permit, adding outdoor entertainment under the use tables of the zoning bylaw as amplified entertainment, whether it's a intensification of a pre-existing non-conforming use. The property is located at 5 Beach Road, Orleans, map number 36, parcel 137. We spent some time hearing this in 2 weeks ago. Since that time, we have received 2 or 3 pieces of correspondence.
Could I interrupt briefly, Mr. Chairman? I apologize profoundly. Is this not something we want the public to hear? Do you want to have to repeat it, or are you looking for an opinion from us? Again, my apologies for interrupting.
No, sir. I'm stating the case again. So we'll see exactly what's in front of us, Mr. Todd.
I have no objection. I just think that
Okay.
you're going to end up doing it again in front of the public.
No, we,
Okay.
a good part of the public was with us
That's
on
why you're the
April-
chairman.
on April
Thank you.
20th.
I accept completely. Thank you.
And we have, and collectively and individually, the zoning board members and the public for that matter, and the applicant and any opponents have memories of exactly what went on. Now, trying to bring it back up to date, since then, I can state, and I think there have been 2 or 3 pieces of correspondence. And there have been, if they were circulated amongst the members of the board, either by individuals who were in favor or in opposition to the applicant. Additionally, both council have provided a substantial amount of documents which would be in the nature of supports to what we really requested were proposed findings of fact. These have been well considered, and I don't know whether, in view of the timing of the receipt by the board secretary, whether all of the zoning board members have been in receipt of this package, totaling in all roughly 120 pages. I'm working through the best way. There are a lot of people, I think, who still want to be heard. And I do want to make sure that the zoning board has a good sense of public comment. Although we have a good amount of it in writing. I set some ground rules in the first hearing, and I don't know that I have to repeat them. From the conduct of the first hearing, I could see that people were generally adherent to my suggestions, that their comments stick with the knitting, were relevant, and brief. We started with hearing from Mr. Kanega for the applicant. Mr. Ruggieri himself testified to us, and Ms. Dalmas for at least 2 members of the public. And since then, I think that now she represents 3 or 4 at least. Also weighed in on proposition. I we had, the sense of the board was that the question was properly in front of the board, whether a special permit should be granted to the applicant. There was a flip side to that, and whether that is, whether the decision of the building inspector to refer the question to the zoning board was merged with that. I think that it's so. So for more or less simplicity, we are treating this application as one for a special permit. So my intention, my proposition is that we hear again from Mr. Kanaga and plus anyone briefly who, any individuals wishing to speak in favor of the application. And then from Ms. Dalmas and her group. Mr. Evers, Ms. Dalmas asked whether I would allow through the chair her questioning the applicant. I will allow that. I'm sure that Ms. Dalmas recognizes that this isn't an opportunity for cross-examination, but mainly some examination questioning that will assist the board to make proper findings based on the evidence. Does any member of the board have any suggestion as to another way of moving this application forward?
Mr. Chairman, I have a question about taking more testimony from the public as to the impact on the neighborhood. We had, not only do we have extensive testimony in the last hearing, but we've all received innumerable number of letters by large lists of people, both for and against. I'm aware of the process and don't want to have shut people off, but I think at a minimum, I don't know that any new information is going to be delivered to this board based on testimony from neighbors, either supporting or opposing. I think the issues are very well joined in terms of the public perception. And I just raised that. I don't know if we have the authority to cut off people who want to be heard, but I would suggest that at a minimum, they be counseled to provide new information. I don't know what new information they could provide. Contrarily, I think that the legal issues look pretty well joined by the subsequent submissions since last week and last hearing rather. And I think if we got into that and again, it's one man's opinion. I don't think it's going to be very productive for anybody to sit here long hours hearing repetitions that either was loud or isn't loud.
Then I suggest to the public and to the board, my colleagues, that the real question is whether there is an intensification of the lawfully pre-existing non-conforming use of entertainment at the Bali Neck Inn.
Mr. Chairman, again, my understanding was that's the question that we ended the hearing 2 weeks ago on. And that was, I thought, the issue we were going to decide tonight.
That is exactly it. To boiling it down.
I regret that I can't raise my hand to be recognized, but not only are we addressing whether it is or is not an intensification, but assuming that it is, are we going to issue it a special permit or not, which is going to turn, if I'm understanding it correctly, or at least counsel for the litigants, the opponents, is going to argue that it has a negative impact on the character of the neighborhood, and that is in some ways, if I'm understanding the case law she's citing, and her argument in general is that that's the singular item that they're resting their case on, is that it is an intensification and that it has a negative impact on the quality of the neighborhood, or however the legal wording of that is. Thank you.
Mr. Chaub, you are correct. The second question is not intensification. Whether there's intensification is one, and the second is the impact on the neighborhood. That is correct. And that was pretty much my ruling. Mr. Kaniga, no, last time we had a hearing, Mr. Kaniga did not object to it, and I don't think he's particularly frightened.
So I would like to then follow up on Brother Mulligan's excellent suggestion. Though we don't want to restrain testimony by the public, we are only taking testimony as to the following, because we can't deny her the opportunity to present her expert.
Oh, no, it hasn't come to that yet. We'll see what happens. Everyone's entitled to a full and complete hearing here, but on the other hand, we've kind of sketched out the issues. Let's hear from Mr. Kaniga first. What do you have to say now?
Well, I think I'm going to lead with the discussion regarding the intensification, if that is okay. So good evening, and thank you all for your patience on this case and for giving us time to bring evidence and draft findings. And thank you for rescheduling this so quickly, because regardless of the outcome, this is really important to my clients to know what they have as a business going into the busy part of the season. When we left off 2 weeks ago, we were asked to bring evidence as well as proposed findings for the question, has there been an intensification of the use? So I'm going to give you a different view of the Barley Neck Inn, previously known as the Pequot Inn, than we heard last meeting. As a brief overview, I've determined that the lawfully pre-existing non-conforming nature of the property began after the vote at town meeting in 1971. If you look at the packet I sent you, you'll see what's labeled as exhibits 2A through D, the zoning maps and the schedule of use tables that changed during that time period. The zoning change at town meeting in 1971 made the current use today and the current use at the time, restaurants with entertainment and sale or dispensation of alcoholic beverages, subject to special permit review if they were in the limited business district, which this district was at the time of 1971. Subsequently, in 1976, it was changed to rural business, and I sent you the schedule of uses, which was updated. So I gave you both changes under Exhibit 2. I think at the very least, and I don't want to speak for Attorney Dowmus, but I think we are both in agreement that at the very least, the change was 1976. But it's my opinion that it was actually probably 1971 that it became pre-existing non-conforming or lawfully pre-existing non-conforming. Now, what was the use back then? Was it a quiet piano bar? People eating by candlelight? I found out that the owner of the bar, then known as the Pequot Inn, from that time period was Bob Gill. A lot of people in town know Bob Gill from Bob Gill's, where I bought my first fish as a kid. He's well known, and I had no idea he owned the Barley Neck at one point, but his testimony is in your packet. And his testimony is that It was the current use of a restaurant with entertainment and sale and dispensation of alcoholic beverages. And it was live amplified music was played at the bar quite frequently. Everyone I spoke to, and I mean everyone, defined the Pequot Inn as raucous. It was loud, counterculture, early 1970s. I've been told some pretty crazy stories that I left out of the statements, but I heard, one point a motorcycle was driven through the bar, a horse was driven through the road through the bar, and an anecdote, I asked about the piano bar to a frequent person or a person that frequented the bar at that time period, and the only one they remembered was one they lit on fire to keep warm one night to keep the party going at the Pequot. So not quite the quiet piano bar the abutters believed it to be. But since at least 1970, the use on the Barley Neck Inn property has been, and indeed still is, it's a restaurant with entertainment and sale or dispensation of alcoholic beverages. Since at least 1970 and prior to town meeting, both 1971 and 76, the entertainment portion of the use, as licensed by the town and state, in both dates, 71 and 76, was live amplified music until 1 a.m. up to 7 days a week, often with the doors open because there was no ventilation and the building lacked insulation. The question is live amplified music on a different part of the property, the lawn of the Barley Neck, under new restrictions from the select board, not previously applicable to the applicant. No more than 4 days a week, no more than 4 hours at a time, and no later than 8 p.m. as an end time, and intensification of use. Keep in mind the use is the same. So I tried to balance it out. So the lawful pre-existing use was music until 1 a.m. The proposal is music till no later than 8 p.m. Lawful pre-existing use was no restriction on sound, exemption, and the exemption from the Orleans noise bylaw. The new restrictions on sound amplification come from the licensing authority, the new license. The lawful pre-existing use was 7 days a week with no duration restriction. The new proposals, no more than 4 days a week and no more than 4 hours at a time. Live indoor amplified music with the doors and windows open inside and what can only be described as not family friendly versus live amplified music in a family friendly environment outside. The abutters cite Cape Resorts Hotels, among other cases, several times, where in that case, a resort hotel, which originally prior to zoning changes provided meals and overnight lodging to guests, and somehow had morphed over the years into a nightlife destination with 3 separate nightclubs on the same premises, was an attempt, that was the intensification. The present case seems more akin to a case, Rubel versus McGee, that cites a lot of the same cases where a small car repair shop began repairing large heavy equipment and storing heavy equipment on the subject property. The judge in that case found that there was not enough evidence of a change in use at the property to meaningfully apply the powers test. So the judge applied it in that case regardless. For present purposes, I believe Chairman Marnick asked us to apply the powers test. So the powers test is 1, does the current use reflect the nature and purpose of the non-conforming use prevailing at the new zoning when the new zoning law took effect? 2, is there a difference in quality or character as well as degree of use? And 3, is the current use different in kind in its effect on the neighborhood? So the first question, does the current use reflect the nature and purpose of the non-conforming use prevailing when the new zoning law took effect? And Attorney Dalmas correctly pointed this out. So we're looking back to 1971. And the nature and purpose have not changed. The use has been and continues to be restaurant with entertainment and sale or dispensation of alcoholic beverages. There has always been live amplified music played on the subject premises, or at least for over 50 years and predating the zoning changes in question. The second prong is there a difference in quality or character as well as degree of use? The abutters and I cited Alameda and the Baron Chevrolet case, which gives us a good guideline. It's the second prong may be satisfied when the use is reasonably adapted to the prior use, is not extraordinary or unreasonable and does not change the fundamental nature of the original enterprise. The proposed use, in my mind, is actually less intense than the original lawful pre-existing non-conforming use. The timeline for the music is shorter. It must end by 8 p.m. instead of 1 a.m. The music cannot be played for more than 4 hours at a time and no more than 4 days a week, compared to 7 days a week prior to the zoning change. And at least as intended by the select board, it will be governed by new constraints under the new outdoor music license created by the town of Orleans. But for this license constraint, the subject premises wouldn't have that. And to quote one of the abutters opposed to the project, Laura Scheel, she's relieved that the conditions living across from a bar are not what they once were. Said slightly differently, the conditions of the use are less intense than they once were. The third prong is the current use different in kind and its effect on the neighborhood? The evidence on record does not support this. There are many letters in support of the current proposal by both direct abutters and residents of the surrounding neighborhood. Interestingly, the abutters who are against the project cite noise complaints, almost all of which came from one person, Stephen Schenfeld, who became an abutter in late 2020, as evidence that the use is somehow different. Upon further review, however, not only did the Orleans Police Department not cite the Barley Neck Inn for any violations last summer, but under its own independent review, on 9 different occasions it was called out, included opinions such as the following: did not appear too loud or boisterous. Music sounds appropriate. Music was at appropriate level. While standing in the parking lot, was unable to recognize the song being played as I could not hear it well enough. The Orleans Police independently recognized that this use is not different in its effect on the neighborhood, especially when viewed along with the Barley Neck Inn staff decibel readings. But once again, most telling is the statement of the abutter, Laura Scheel, who's been a resident since 2004, which indicates the proposed use is actually less intense than the pre-existing non-conforming use, lawfully pre-existing non-conforming use. And the distinction today, many of these, the surrounding neighborhood wasn't exactly there at the time. So with this new evidence presented tonight with the owners of the bar in the 70s, and the actual use in the 70s. We think that when the subject premises became pre-existing non-conforming, coupled with third-party perspectives from both neighbors and independent review of the Orleans Police Department, the new information regarding the permit, I believe that the powers test has been met, and the current use is not more intense, an extension of the lawfully pre-existing non-conforming use from 1971 or 76. And I think with that information at the time, it may have changed Commissioner Evers' decision.
Well, Mr. Knager, is it fair to say that the proposed use in 2022 is no different than the licensed use in 2021?
Yes, I think that's fair to say, yes.
In other words, there's nothing new coming on, no new conditions sought to or to be more accessible.
Sorry, I think this is the first year it's actually been in place for the whole town. So that this license just was issued to the second applicant. There was a third one today, actually, last week. So I don't think it was, previously people have been operating under their existing entertainment license when operating in entertainment outside. So this new license is actually new as of this year. It's not the same as last year. The whole idea would be to, or at least the discussion the select board has been attempting to have is how can they balance the interests of the public with the neighbors if there are issues. And that's the purpose of a licensing authority. They have the power over noise created by a license, granted license, or overuse or misuse of the granted license.
That they do, but we have it now, and under 164-44, the zoning board is allowed to attach conditions to the special permit. Thinking was, if that were lined up, if we were to provide relief to the applicant, then we could attach conditions, say, that would be identical with, the conditions that you proposed in 2000, going forward in 2022 and sequential years, as you had in 2021, which was by a direct conduit, so to speak, from the Board of Selectmen, who at that time were using their licensing jurisdiction to take care of it, instead of treating it as a use, which is really, that's what zoning boards for.
Yes, and I also can dovetail, I have a special permit presentation, but effectively, and you said this last time, Mr. Chairman, with your discussion with Attorney Dalmas, I mean, really the review of substantially more detrimental is just a heightened review of what we just went over with the powers test, with noise probably being the one discussion point for a special permit review. So I'm happy to do it, but it's a very similar.
No, those, we're quite familiar, all
Right.
members of the zoning board are quite familiar with those categories. What I think is that we're grabbing right onto the three prongs that you just sought to justify the application. And we appreciate that. Now, is there anyone wishing to speak through you in favor of the application that would cast, as I said before, white red?
If I may as well, Mr. Chairman,
Yes,
I asked
yes.
that I have several people that wrote the letters in late, but I think the general sentiment is that they tried to get the letters in to you for review. Especially, I kind of targeted people that were in the neighborhood to try to target down the support you might hear. So if no one's speaking, it may be because many of them have written in.
Members of the board, let the record reflect that at least I am in receipt of some of the material provided when Mr. Kaniga included a uninterrupted set of affidavits, that is from, say, 1971 to the present owner of the Valley Neck Inn, establishing the use of a loud fun bar, entertainment and music, extending from Mr. Gill through Joe and Kathy Lewis. Don't know that that's any longer in dispute. The way we characterize that might be a different story, but I think that's established by the evidence. I might, does any member of the board have any questions of Mr. Kaniga? There's no positive response, therefore, I'd like to hear from Ms. Dalmas.
You also just had a hand from the public go up. Do you want me to bring that person in, Mr. Marnick?
Don't know who it is.
Mr. Squire, I can bring him in if you want.
I think I have an affidavit from him. Let me just check.
You do have a letter from Larry, Mr. Chairman.
I thought I did. Let me
I'm trying to bring in Ms. Dalmas, but she's not responding.
We'd have to hear from her. All right, well, to allow no gaps then, let's hear from Mr. Squire.
I'm sorry, you would like me to bring him in?
Yes, yes, please.
Okay. You also have two more members of the public after that who just raised their hand.
I thought so.
Okay, so Mr. Squire, you should see a little window pop up. Just click yes. There you go.
Squire, could you identify yourself and where you live? You, Mr. Squire, okay, can you connect your audio? Good.
Good, good evening. I'm sorry, my technology skills aren't that finely honed. I did submit a letter on behalf of my wife and so I didn't jump in initially because I was heeding your good recommendation not to be repetitive. But we are neighbors of sorts. We've lived in this part of town for 35 years and have gone through all of the history that Mr. Kanaga outlined. And one of my points, especially on I guess the third prong, is that as we drive down and have experienced, drive down Main Street and see the folks out there enjoying what the town has tried to promote since I was branch manager in town almost 50 years ago, and still has work to do. This is exactly what they envisioned as something that would promote the town of Orleans as a place to visit and live. So the noise issue, to me, we sat in the parking lot, we've experienced it many times. It's to us a non-event. Now, maybe that's because of our age and our hearing isn't as good, but to not allow this to happen, to me, is inconsistent with what the town is trying to do to promote cultural events. And the rest of what I could say is either in my written comments or comments I had for the selectmen last summer when there was a hearing on this. So we very much in support of this and hope you would see it that way.
Thank you, Mr. Squire. Ms. Thomas, we are going to hear from two other people who raised their hand before I saw you on the screen. And then we really want to hear from you, summary. Mr. Stewart.
Good evening.
Very well.
Yeah,
Now, where do you live?
I live on Skakit Beach Road down in Northwest Orleans, and I had a long 2-page, 3-page letter to read, but I'll summarize it because my guess is you've heard most of it from other people, and to reflect on a couple things that Mr. Kanaga and Mr. Squire have mentioned tonight. First, I do want to support this idea that the use of B&I for entertainment hasn't increased. If anything, it's decreased. I've been going there since I was a kid in the late 70s. My mother worked there in the 80s. I learned a lot of things you're not supposed to learn at a young age by attending the Barley Neck Inn and some of the artwork in the restrooms and the music and Mexican nights. And even into the 90s, the Barley Neck was much more crowded, much noisier than it currently is. I think that recent residents might be basing it on kind of some slow years for the economy and slow years for the Barley Neck and transitions in ownership. And just as BNI is getting back in its groove and finding a business model that works with outdoor music, and it still is much mellower than it was. I know you mentioned earlier that the change in quality and character of the entertainment and impact on neighborhood, but I think it's important to realize that I mean, the biggest change in quality and character in this case has been the neighborhood, not the restaurants, and the restaurant shouldn't be faulted for the neighborhood around it evolving into something that may not want it there anymore. And as soon as we start driving out culture that is right behind the cultural district sign, then Orleans isn't a town I want to be in anymore. And I've lived here on the Lower Cape for my entire life, and it's sad to see the potential for what is pretty mellow, fairly quiet outdoor entertainment that, as Mr. Squire said, is exactly what the majority of this town has been trying and worked so hard to cultivate. So my hope, I'm sorry, I apologize, I'm just going to keep it short, but my hope is that you as a board can support live outdoor music, be it at BNI or as it comes across from other applicants, because it's something that we sorely need in town. So that's all. Thank you so much, and thanks for working on this.
Very well, Mr. Stewart. I think that what the zoning board is working at is properly administering the zoning ordinance and not necessarily making an endorsement as to whether music is desirable outside in the town, or endorsing a proposed business model for the Barley Neck Inn. The real question is what's happened there since 1971, but maybe even more immediately, what the uses have been in the past 3 or 4 years. Thank you, Mr. Stewart. Ms. Hackett.
Thank you.
Do you want to make a statement to the board?
Am I live?
Yes, you are.
Oh, good.
And Ms. Hackett, where are you from?
I have property on Pochett Road in East Orleans, and I've been coming to the Cape since I was 4 months old. So I'm not a wash ashore really, although I've retired here for 14 years. But I go to the Barley Neck Inn all year long, and I go probably once a week to once every 2 weeks. And I guess my comment is more about noise than anything else. The staff is wonderful, the ownership is wonderful and all that. But last summer, my niece and I heard about what was going on and all the complaints about noise. And my niece and I decided on 4 different occasions, somewhere between 6 and 8 o'clock at night, to walk from the Whisk, you know where that is, the Whisk restaurant, up to the condos that are behind the Barley Neck Inn, both on Pochett Road and on Beach Road. And on all the occasions that we did that walk, we did not hear the loud music. We could not hear it. We sat outside in the tent that they had last year and the year before for dinner. We could not hear the music in the tent, which was right in their parking lot. We could hear the music when we went on the lawn, or if we were on Pochett Road right behind the man that was playing the guitar. We stood right behind him. We could hear music from the 60s and 70s and maybe the 80s, but we weren't listening to Metallica, Led Zeppelin, loud drums or anything like that. It was family oriented, you know, Peter, Paul and Mary sing along music. And the one thing that I noticed that really warms my heart is to see grandparents, parents, and young children out on the lawn enjoying the music dancing, playing cornhole, blowing bubbles. This is the kind of atmosphere I think that Orleans wants to promote. They want families to come to Cape Cod. They want families to live here, visit, and it's a family-oriented activity. There is no vibrating music that possibly can vibrate a house. I'm sorry to say that, but it can't possibly do that. But I think this is the kind of music. I go to the baseball games in town and there's music there until 10:30 at night. I go to the Hog Restaurant or the Tavern. There's music there that you can hear much further away than you can hear at the Barley Neck Inn. And it's a different kind of music. And I really think it would be a shame to not have this kind of family place in Orleans. It would break my heart to see it not happen. So I don't know how many of you have even been to the Barley Neck Inn and listened to the music on the lawn. I have no clue, but it is not loud, offensive music. Thank you very much.
Very well. Thank you, Tackett. Ms. Delmas, the floor is yours.
Do you not want me to bring in the other members of the public?
No, I think so. I made a deal with Ms. Delmas, but she
Okay.
have two more now. It's really your turn.
Great. Good evening, everyone. Victoria Dalmas, Sunny and Associates, 15 Cape Lane. Thanks, everybody, for all the effort put into this interesting hearing. Through the chair, I'd like to ask a few questions, if I may. And then I would like to introduce our acoustical engineer, Mr. Richard James. And also, I would like to ask the board if I may submit his CV for the record.
Yes.
Thank you. So through the chair, for the applicant, and thank you for doing the research on the actual pinpointing the date, the relevant date. First question is, was the entertainment that you've mentioned in 1971, was the liquor service that you've mentioned in 1971, and was the food service that you've mentioned in 1971 conducted outdoors at the Pequot Inn? And if so, what was the frequency and the timing that such outdoor activities were conducted?
I am not aware of the entertainment being outside, which I think is the main question you're asking. And it's not part of his testimony, but the Bob Gill did indicate that he had gotten the inholder's liquor license because it allowed him to serve alcohol throughout the entire premises. The licensing at the time, you can't find it. I've looked as well as I could. I think I got it back to 1980, but I couldn't find it, the specific license for 1971, other than the owner at the time, the operator at the time, indicating he did indeed have the inholder's license for that purpose. It was a much different property too at the time. If you had a pool area and a motel and I mean, it was different. But yes, so no to the entertainment, which I think was the original question.
Okay, so we know that there's a fundamental difference between inside and outside, right? Is that fair?
Well, I think that my testimony, well, my statement was indicating that it was a completely uninsulated building that they would blast music till 1 a.m. with the windows and doors open. So I understand that, yes, inside and outside have different definitions. But my point is that I don't think it's a fundamental difference to the extent of loud music amplified into the night, especially considering the time. 1971, there were less people. There was less traffic on Beach Road. It's, you know, the late into the night, especially, people drive less late at night. Just as right now, I can look outside, there's less
Okay.
people passing by the hour.
Okay. And in 1971, was there a tent put outside on the premises? Which
Right.
today, under the bylaw, would be a new nonconformity?
I have no knowledge of a tent or not back then.
Okay. And under bylaw, section 164-27, which is relevant to tents. And I understand the application envisions putting a tent on the lawn premises. Is that not a new nonconformity?
I don't know. I'd have to look at that. I'd have to get testimony as to tents. I was looking at the intensification of the use as to the
Well,
noise.
the presentation of or the implementation of a new nonconformity is by definition an intensification. And a tent under the terms of that bylaw section is a prohibited.
Right, and my answer back to you is I don't know if there was a tent, but I'm pretty sure if that is your problem with this, my clients would remove the tent.
Okay. Okay, and I had heard that you had said there was one complaint primarily from one abutter.
One complainant.
Okay. Well, the evidence in relation to the show cause hearings with the select board indicates several abutters were involved in the complaints about the noise levels.
I was police complaints.
Police complaints. Okay,
There were-
so I
there were
just,
nine noise complaints to the police, 8
Okay.
of which were from.
how many
TV
times
channels.
were the police visiting the premises?
9.
9 times, and what dates and what times?
Give me a second here.
Mr. Chairman, could I interject for a moment?
Mr. Todd, please. Yes.
I apologize. I find this questioning to be in the form of what I would consider to be cross-examination, and I don't think it's appropriate to the board. If Miss Dalmas, the Attorney Dalmas, wishes to present this evidence, she can present it affirmatively. But I'm just not comfortable with this kind of, one law. I just don't get it, Mr. Chairman, so I apologize, but it's making me uncomfortable. Thank you.
Sorry, Mr. Todd. I'm going to allow Ms. Thomas to continue a bit further.
Okay, my apologies, Mr. Taub. I don't mean to upset you. I just have one last question, then I would like to turn it over to our acoustical engineer, Rick James. And I just draw through the chair, Mr. Kanaga, bylaw section 164-3C5. And this is more relevant to the substantially more detrimental analysis once you get past intensification, which I do believe the shift to outside entertainment with use of tent is triggered. I wanted to ask you if I had heard that there may have been periods over the course of since 1971 to the current date where there were no entertainment uses going on. And that reversion clause in the bylaw is relatively strict in terms of once you cease a non-conforming use, so such that it's conforming, you can't flip-flop back to the non-conforming use. So I just wanted to draw your attention to
Mr.
that.
Chairman?
Yep.
Could we ask for some more specifics around that? Hearing statements like "I have heard" with no specifics, no source, no date. I have an issue with questions phrased that way and for evidence to enter into the record as such. So I just asked for some more specifics.
Really, Mr. Chairman, I would like to repeat that the statements of law being made by counsel, there's 40+ people on this call, and she is not competent to opine as to the law in this form at this time. If she wants to present her case, great. I don't like the cross-examination part. And it's not that it makes me uncomfortable personally, it's that I think it inappropriate, sir.
Very well, Mr. Traub. The point taken, Mr. Cole. The fact of the matter is, I think that the point being made here is whether there'd been somewhere along the line for some appreciable period of time, there had been an abandonment of what would otherwise have been a non-conforming use, so that it couldn't be ever reverted to to its non-conforming status. Was that the point, Ms. Delmas?
Yes, thank you.
That's what I thought. And that's a question of evidence, and we're well aware of the rules concerning abandonment, which is generally 2 years.
Okay, so with that, through the chair, I would welcome introducing our acoustical engineer, Richard James.
Mr. James, can we hear from you, please?
Okay, I'm hoping coming through.
Yes.
Good, good. I don't have a prepared statement. Basically, what I've done is I've looked over a lot of the material and read the applications and looked at local laws. And I have to say that much of what has been presented to you as facts or as evidence about noise is really just misconceptions from people about their subjective responses. Some of the objective statements, particularly from the complaints, and I'm going back to one of them that was about being able to hear low frequency noise and feel vibrations in the walls. I run across that very commonly when we're dealing with music from instruments, amplified music, particularly bass drums, bass guitars, even some of the lower notes on guitars and keyboards. That kind of sound travels great distances. I think we're all familiar with the boom boxes that some people have in their cars, where you can hear the bass beat blocks away from where they are. That's kind of what we're looking at here with outdoor music and amplified. When I look at a community, and I've got 50 some years experience since I first picked up my first sound level meter, even before the permits for BNI. I was doing noise surveys for Chevrolet in 1968. So I've got a lot of experience with sitting out in quiet areas, rural areas, listening for sounds. Due to complaints, I represented GM, Ford, Anheuser-Busch, number of other big companies, all of who had strict requirements not to get their brand ID caught up in complaints about noise in the local newspapers. So they were hiring me to fix the problem, not to cover it up. And what I hear here is some people who want to make some changes for business. That's good. But they have no understanding of the impact of the change that may be beneficial to them on their neighbors. There's a concept called noise trespass or trespass zoning, noise being one of them. And what that says is the music that the people who would be sitting on the lawn are enjoying, at the point where that energy crosses the property line, becomes pollution. It's no longer music, it's noise pollution. Noise pollution is not acceptable. So when people who are talking about the benefits of this project for entertainment, et cetera, they're looking at it while they're within that property line. They're not looking at it like a neighbor would. So how do I get an idea of what a community expects? I look at their laws, particularly if the laws have been around for a while. And if I understand the Orleans noise regulation correctly, it basically says that the intent of the town board at the time they wrote that standard was to eliminate any sounds that were audible at a distance over 150 feet from the noise source. Well, that's the bulk of the residential properties, although some of the, I recognize the name is Laura, lives just within the 150-foot boundary. The rest of the complainants are far beyond that. If it is audible now, it will still be audible after that tent is installed. And that is because when you put up a tent with noise barriers around the perimeter, the noise goes right out the roof. We may say, oh, look at the nice noise barrier here, but sound goes over walls. Sound goes up and up through the roof, hits what's called the temperature inversion boundary, which at night may be a couple 100 feet above the ground, and bounces right back down to earth. So the wall that they're talking about isn't going to provide any real attenuation. They may as well be playing the amplified music out at night without any wall, without any tent. And I think everyone would agree that that would be a problem. So I see a lot of dreaming going on here. I even investigated some of the panels that would be used for the wall. They have almost no ability to attenuate the sounds that are in the range of bass guitars, drums, even the lower third of any keyboard. The ability to block those low frequency sounds is a problem. And for many years, and this isn't always a community problem, it's even a problem in occupational or other commercial environments. Low frequency sound, which is the bass guitar, the bass drums, the thumps, the bumps, the rumbles, is known to be more annoying, is known to be more of a nuisance and a source of adverse health effects. This is codified both in US law and in the World Health Organization's guidelines for noise. If right now we have complaints that we can hear the rumble, the bass, the guitars at 200, 300 feet, you'll still have those complaints if the permit is granted and the project proceeds as indicated. Spreading the speakers out around the perimeter, that's a great idea, but for every speaker that's pointed away from the residents, there's another speaker that's now pointed towards the residents. And like I said, that sound will go right up over the top. It reflects off the interior walls and it gets out. It's just the nature of noise. You can't have any openings. So anyway, what I see here is a situation where the business owner is just not recognizing that his music becomes noise pollution to the neighbors. Low frequency is the primary source of the complaint. That's a well-known cause of annoyance. Annoyance is an adverse health effect. I'm not talking about the kind of annoyance where mosquitoes flying around and you say, oh, that's annoying me. I'm talking about the kind of annoyance where people stress out, where their blood pressure rises, where their anger lingers, that have long-term impacts on not only family relations, but on cardio and other biological systems. These are well understood. Low-level noise may not be a danger in the short term, but in the long term, it's an adverse health effect. What I guess I'd like to do is to open it up for questions, because you heard an awful lot about acoustics from people who know very little about acoustics. And if you have questions from having listened to them, I'd love to have an opportunity to answer them.
Mr. James, did you observe or visit the Ballyneck Inn last summer while there was a band of amplified music was being used outside the bar?
No, I have never been to Orleans. My family landed in Boston in 1635, headed to Maine, headed to Vermont, headed to Illinois, and I've been a Midwesterner ever since. I worked on several projects in Massachusetts, the Falmouth wind turbines, for example, but I have never had the opportunity to visit. However, this is my profession. I've seen this situation many times. A band amplified is a band amplified. It depends on what the band is doing. I mean, if we were talking about a all acoustic band, no microphones, someone sitting outside like in a coffee bar playing some folk music, that would be one thing, but we're talking about amplified. And once you go amplified, the problem becomes almost unsolvable, and it will vary. There'll be days when there's no problem because that band is quieter. There'll be days when there's more of a problem. If there's a band that happens to have a good audience response and everyone starts singing or clapping or cheering, then we not only have the noise from the music affecting the neighbors, we have the noise from the people who are enjoying the party. All of these things are, I understand, are have to balance out. But given that we already have a track record of complaints and that the proposed solution will do little to nothing to reduce those complaints, my suggestion is this is an area that deserves to stay as quiet as it could be. The ordinance for the town shows a predisposition to avoiding noisy events. And I think that should be the way this is interpreted.
So you have no data in the nature of findings or records from any sound meters showing the relative loudness?
No, but I have experience that would supplement that. Number one, I don't know that any proper measurement was taken. I noticed there was some talk
Chairman,
about
I really
70 dB.
object again. I apologize. The answer to your questions is yes or no. If you want expounding, ask for it, and the witness should please respect the time of 48 people who are on the call and have heard this.
Very well, Mr. Taub. I'm giving Mr. James the dignity of describing whether simply, and I think he's getting to the conclusion of his answer, that he's got no data measuring on the ground at the Valley Neck Inn. However, he's relying upon his experience. Ms. Dalmas will be allowed to submit the curriculum vitae or resume of Mr. James as an expert. The question and then will be before the board to what credit to give to Mr. James' testimony. Quite clear what his testimony is and what the basis of it. So, Mr. James, you don't have any data from any noise or sound metric devices at the Valley Neck Inn?
Yes, I thought I made that clear earlier when I said
right.
I've never visited.
Very well. Ms. Dalmas.
Mr. Chairman, the witness
Taub.
invited questions.
What was that, Mr. Taub?
I said the witness invited questions. I'd like to be entitled to ask one.
Yes, you may.
I guess I have to say something. I pledged myself not to say anything, Mr. Chairman, till the end of the meeting. But there are 48 people in the public on this call, and I'm aware of them. And in my humble opinion, we've accepted his resume and his qualifications as an expert. But because of the importance of what expert testimony means, and forgive me again for my lawyering here, but anticipating the possibility of appeal, it just seemed to me that I wanted something in the public record that indicated that he was being presented as an expert as opposed to a fact witness, if you will. And that's unique in the law, for better or worse. Experts are allowed to offer opinions, which are allowed to have worth that other opinions might not. And lastly, we're allowed to believe or not believe it.
Do you want me to charge the zoning board with the principles of law that apply to the receipt of expert witnesses, Mr. Taub?
No, I don't, sir.
Well, I'm prepared to do that. What you
No.
say is an accurate statement. The question is, we'll all decide what credit to give to the testimony of Mr. James. He is an expert according to his resume. So-
Okay, I'm good with that. And again, I'm hypersensitive to the number of people who are watching and
I understand that.
and the danger of lawyers or others stating the law for the public. It just makes me nervous. Thanks, Mr. Chairman.
It doesn't make me nervous at all. This is a sophisticated zoning board of appeals that's been in most of all of the members have been on this board for several years and know exactly how to make findings of fact and the basis for them.
I meant no aspersions on the board. I was only being attentive to the audience. You're doing a wonderful job, Mr. Chairman, and I'm not being anything other than candid. Thank you.
No,
for
I
your-
understand that.
Thank you for your guidance. I noticed Mr. Kananga's hand up, and I don't think it's appropriate unless he's going to ask a question directly of this witness.
I suppose I can't allow that, Mr. Connect.
So I appreciate Mr. James coming. I have as a person who lived in the Midwest for quite some time, I like it out there as well. But I also contacted a sound engineer. My issue with this case was to recreate. So the question is intensification, Mr. James, and to recreate 1970 or 71 really, with loud amplified music at 1 a.m. in an uninsulated building with windows and doors open. We would have to have a rock concert at 1 a.m. or midnight, and then have a comparable. So what is being proposed out on the lawn? We didn't think that possible in the last 2 weeks, and probably not appropriate given the coverage this is getting currently. But you said the low frequency sound carries, and I think that's, even without an acoustical degree, someone that played music for some time, common knowledge. And low impact or impact bass, but also low frequency bass music in general carries. It carries through walls. But worse is when there's no, you said that you can't have any openings. And so my question would be, wouldn't that be similar to a completely uninsulated building from 1970 with the windows and doors open, blasting low amplified music?
I think that building had a roof on it. I don't see I don't see them as being comparable. You have a building structure that is containing the sound versus a tent with a little wall around it. They're not equal, nor do we have any idea what the music is. Sounds carry, the low frequency sounds carry great distances. We know that because we hear a thunderstorm roll in, and the first thing you hear is the rumble. It may be 5-6 miles away. The low frequency sound travels. And the rumble from a thunderstorm is in the same frequency range as bass guitars and bass drums. It just travels. It travels and travels. The other thing is, in comparing noise, I noticed there were some noise readings. I have no idea if the meter was qualified, if it was calibrated, if the person using it was even trained to use it, but it appeared from the noise readings that were provided that they were all readings about cars passing by, trucks passing by. Those may be temporary masking devices for a few minutes, but this road, I looked up the Department of Transportation data on it. It's 3,000 vehicles a day. That's not heavy traffic. That's the kind of traffic, I think it was 30 mile per hour, 35 mile per hour speed limit. That doesn't provide highway noise. The traffic noise there is from some trucks or some cars that don't have proper mufflers. But in between those cars, you're going to hear all the music. And for someone who's living not right on that road, the music will probably be louder than the vehicles. So I don't see that 1971 has much, if anything, to do with now. We're talking about a tent, not a building. And we're talking about music with modern amplification. I don't see any equivalency.
And my follow-up, because 1971 is what we're tasked with comparing it to, is the reason that date matters. But the follow-up would be, again, loud music with amplification at 1 a.m., no traffic, doors open, no insulation, versus music on the lawn without bass and without bass guitar.
I haven't seen anything that said that that the music that you're talking about would be without bass or without bass guitar,
But if
or without keyboards or without anything else. I mean, that it's apples and oranges. The system has to be looked at as the increase in noise over the way it operates with bands inside. And when you let the band go outside, then that completely changes things. If they were building a structure around that, let's say an auditorium, that might be different, but this is a tent.
Okay.
This is a tent with some cotton bat walls around it. It's entirely different.
All right. I think that that concludes the examination. And cross-examination. Thank you. Mr. Chairman.
I'm sorry, you broke up on me, sir.
I think that concludes your testimony. We all appreciate it.
Oh, okay. Thank you. Thank you.
Ms. Thomas?
Yep, I don't have any further questions. I would like to, if I may, have Laura Scheel and then the other abutters have the opportunity to speak.
Do you have a concept of how many would be speaking?
I believe we have Laura Scheel, Beverly Chapel, Katie Day, and Ward Gorey. So 4 speakers, and they've all agreed to keep it under 5 minutes.
Very well, proceed.
Thank you.
Those individuals may be admitted.
Okay, I see Katie Day, I see Miss Chapel. I don't see, I'm sorry, Laura Scheel. Can you repeat the names of the other two, Ms. Thomas?
Yeah, Laura Scheel and Beverly Chapel.
Ms.
And then-
Day, can you proceed? Can you tell us the board where you're from?
Did you say me, Miss Day?
Yes.
Okay,
yes,
sure.
Ms. Day.
My name is Katie Day. I'm at 224 Main Street, which is right next door to Laura, and I believe within or very close to within 150 feet. I've been there since 2009, and I also used to work at the Barley and Neck on and off. I have a couple of points I just wanted to bring up as a neighbor. I absolutely feel it's unquestionable intensification in use since I've been there. There's been many bands inside. There's never been constant outdoor music. A couple Santa stampedes here and there is one thing, but consistent 4 nights a week music that's loud in your front yard is different. I just want to say also that I think there's a lot of support around this for the town, and that I understand that it's one thing to choose to, hey, do you want to go to the Barley Neck and listen to music tonight? Sounds great. It's an entirely different thing to live right next door and not have a choice. And you have to hear it, and you live in an old house with no AC and the windows are open and it's just constant. It's 4 nights a week. I also want to say that I think the license that has been created doesn't allow for any sort of noise ordinance. So that means there's going to be no restriction on how loud this can get or can be. According to how the new license is kind of set up, there's just, it's loud, it's outdoor, it can be what it can be, and there's nothing we could do about that. And I also want to say that I think we keep talking about, like, this is outdoors, it's from 5 to 8, but it doesn't, this new license doesn't stand in place of the fact that any owner, current or maybe future, because we know the Barley Neck has been for sale, the current owners have tried to sell it, isn't gonna continue to have music at night. It doesn't take away their ability to have any sort of other music. And my other point I wanted to say is that as a neighbor, I feel, I don't see why, I guess, like, there's no talk about, we could do something unamplified. They could have happy hour and have indoor music, and people could still be out on the lawn having drinks and playing games and doing things, but having amplified music when you have no choice but to listen to it 4 nights a week, where you want, your windows are open, it's summer, it's just it's a totally different thing to live right next door to it every day. The other point I just want to make quickly is just that people are kind of making it seem like there's no music in Orleans, but there's a lot of music in Orleans. I would say, like, there's an event called Live in Orleans, where every Tuesday night in commercial areas in town, there's outdoor music. I think a lot of people know that and can look it up. There's concerts at Nauset Beach. There's the Clambacue. There's a lot that the town has put on. And there's plenty of opportunities for families to get together and enjoy live music.
Thank you, Ms. Day.
All I have to say.
Thank you.
Yep, thank you.
Ms. Chapel, can you identify yourself and where you live?
Hear me okay?
Yes.
Oh, good. Okay. Well, my name is Beverly Chapel, and I'm also representing my mother, Mary Ware, who's 94 this week and is not on the call. I'm in New Hampshire, but
Ms.
I am.
Chapel, let the record reflect that we have an affidavit from you.
Yes, thank you. I saw that. She was very nice to do that. I want to thank you for letting me speak tonight. I'm in New Hampshire, but I'm on the Cape quite frequently. I'm there with my mom almost every month, and so I've lived there. So I want to thank you for letting me speak. But our family home, if you're not aware of all of where the abutters are, we abut the Barley Neck Inn to the extent that we're so close that when their overflow parking is essentially right in front of the house, and we hear the music from within the bar in the house on the weekends all the time. We just have always done that. It's always been there. We were first made aware of the proposed activities at the Barley Neck in this regard in 2021 from an article that was published in the Cape Codder. And we submitted a letter of our concerns to the Board of Selectmen at that time, and I attended that meeting. And when we were notified of this meeting, I also sent in a letter of our concerns reiterating the same ones that we proposed to the Board of Selectmen, but for some reason, none of those letters have been made part of the record. It was our understanding that the Barley Neck received temporary permission from the Board of Selectmen to engage in these activities as a limited exception due to COVID. And when the temporary permit was in effect, the music on the lawn was clearly audible at our house and in our house. And while we were over 300 feet away, but we did not protest. We did not complain about these activities because we thought they were temporary. And we thought they were being supervised as under an emergency response afforded the Barley Neck during an extraordinary and unprecedented time of the pandemic. Given our history with the Barley Neck, we had no expectation that they would take advantage of a courtesy extended to them by the Board of Selectmen and their neighbors to turn this into an opportunity to what looks like expand their restaurant business to an event venue. So we're concerned. Our history with the town is my parents built our family home in 1976. I grew up there. I worked for the Nicolais as a chambermaid. I skateboarded in their parking lot. We were friendly with the Nicolais, and my parents maintained a very good relationship with Joe and Kathy Lewis there. And it was very supportive as well. I was residing at that residence from 1976 to 1986, and I can honestly say that I don't recall any outdoor music events at that location on the lawn. And my mother, as you have noted, has submitted her affidavit to the same, and she's been there since 1976 to the recent events. My mom is in her mid-90s, as I just said, and she's been alone since my dad passed in 2014. And while she's in relatively good health, she is housebound. And she's worried how an outdoor event venue would affect her health because, unlike others, she would not be available. She could not leave her home if she were made uncomfortable. She is, she's not afforded that liberty at this time in her life. And that, I think, is a consideration because it would be unacceptable to make someone uncomfortable in their home with health conditions. We've been informed by a realtor that if an event venue was to prevail and to be at that location, special consideration would have to be given in the future. Should we choose to sell that home, we would have to disclose the activity. We would have to limit when we could show the house based on when the performances were, and we could ultimately expect a reduction in value. But more on another note, I'm really concerned that the ZBA, I really appreciate your hearing me, and I did time this to try to get as much of this as I could because I know there's other people who want to speak. But there seems to be a preponderance of promoting a lot of the support from people who will not suffer a direct consequence from the outcome of your decision. And if they're given the impression that their influence, the popularity here is not an issue. The popularity of the Barley Neck Inn has never been a factor in the instance in this situation. And no one is maligning the reputation of the Barley Neck Inn. The popularity of the Barley Neck is not germane to these proceedings because, in my opinion, the only matter before this board is the applicant's compliance with zoning. And I'm mentioning this because, to be honest, I'm a little worried that by mentioning any or voicing any opposition to the applicant's business ambitions, I could be subjecting myself or my mom worse to public humiliation or intimidation because people perceive that they have a right to party. But I sincerely hope this isn't the case. And I just think the uncomfortable truth here is that if the Barley Neck is permitted to transition its business model from a restaurant enterprise serving food and liquor with entertainment inside to an outdoor amplified music venue, you're essentially holding all of the surrounding residents and businesses alike hostage to the business aspirations of one property, one business. And I think that should be unacceptable to everyone. Other than that, I've read the applicant's application to appeal and to obtain a permit. And I'm thinking that the application in itself is deficient in detail that actually satisfies the requirements for the ZBA to even give approval to this. It looks like a complete disregard for process. It introduces mockery with comments like the fun police, and it suggests a clear intent to circumvent zoning and other procedures usually required to prevent illegally expanding non-conforming businesses. For instance, does the applicant really expect the board will accept that multicolored pastel Adirondack chairs are a sufficient enhancement to the character?
No, Ms. Chappell, I don't think that that's germane to this hearing.
Oh,
And I think you maybe have spoken with me.
okay. All right. Well, then I do have one question because I do need a clarification from the board. In speaking to the hours, I'm confused. Is the applicant considering ending its internal live entertainment in favor of an all outdoor music venue? Or will they be both? Are they going to continue their normal operations of having music on the inside while having their outdoor events earlier in the day?
Well, we weren't, I thought under no circumstances were we considering any diminution or change of the music inside the bar. Mr. Nager, I think aren't we just talking about that 4 to 8 time slot for like 4 days a week?
Correct. In the outside lawn, I would not call it a music venue, but.
Well, it doesn't make any difference what you call it.
Okay.
Factor,
Well, so-
but, you know,
So
that's-
I'm sorry. My
okay.
point being that, so my assumption was that they're going to have music on the lawn from 4 to 7 or 5 to 8. But then they would have on Fridays, Saturdays, or their other schedules, they would have music in the bar from 8 to 11 or whenever they normally close. And if that is the case, then aren't they intensifying the total number of hours of music that they're presenting each week?
Well, I'm not going to answer that question.
Oh, I'm
That's not for the determination.
so it isn't, I'm sorry, I'm just asking for clarification because I don't understand the nature. If we're looking towards an intensification or a use, wouldn't the expansion of music in hours be an intensification of the use?
No. Mr.
Oh.
Gorey, do you want to talk to us now?
Yes, thank you. My name's Ward Gorey. I live
And you are
on-
the author of a letter that's already been received by the board.
I am, yes, sir.
Proceed, please.
Okay. So I live on Brick Hill Road Extension, which is approximately 2,000 feet from the Barley Neck. And I was, I have to say I'm confused here. And I'm sure you don't need to solve all my confusions, but it seems that the standard that we're trying to meet has shifted now. And now that the question becomes, can we honor the conditions that were in a bar?
Sincerely.
Mr. Taub, I think I am speaking now.
My apologies for not being on mute, sir.
Okay, thank you. The question is whether we're supposed to now consider the baseline standard, this infamous Pequod back in 1971.
Why is it, you know, we don't need infamous describing the Pequot. Do we?
That's, I don't know whether you need it or not, sir, but I'm
Why
saying-
did you use the word? Are you characterizing?
I used the word because it
something
was,
you know?
sir, it was described by the Mr. Kananga as a place where things would occur that were, he learned things earlier than he should have, I think was one of his phrases. I think he mentioned that the noise went on till 1 a.m. Is that our standard now? Is that what we're saying? We're trying to preserve. We're going to match that. That's the confusion that I'm having. I thought the question had been, was this an intensification of a use that had been there before? And the previous hearing, there was no mention of this time. So, you know, one of the things, let me continue with my regular statement. I'll come back to this point. I heard music from the Barley Neck about 2,000 feet away in the summer of 2020. And there's someone had mentioned grandchildren. My grandchildren were here with me. And my grandson said, why does that man keep yelling? We got to get out of this place. he noticed that something was different in degree and in character, that the lawn where we could play was now being invaded by these new noises. And that was what concerned me. I felt helpless about being able to control noise that at that time was neither licensed or permitted, as I understood it. And I felt sympathy for the people who were being roundly criticized as trying to express their concerns about this. To me, if there is going to be amplified music outdoors, played 3 hours a night, 4 nights a week, that is intensification. This is an increase in what was going on before. I think the point that was tried to be made before about reversion, that if from that time in 1970s, there had been times, thankfully in my mind, where a quieter form of music was played indoors, that now we're supposed to say that because there once had been this loud music that could be heard through the uninsulated place and out the windows, we should go back to that. I think someone said that, you know, why should the business have to represent, you know, change when the neighborhood changes? And I'm saying, why should the neighborhood have to handle music that has died down over times from a very noisy period of time back then? I'm concerned about the presentation, the proposal that they have a tent and that the tent be erected through the summer. I think it looks like the circus has come to town. If there is a large tent in front of an imposing captain's home, and if abutters have to see that tent going in and out, and if all the people traveling back and forth to Nauset Beach have to see that tent, that to me is a change in degree and difference. So I guess I'm having to say that trying to follow these hearings has been confusing to me. And I'm concerned that we're trying to go back to honor a standard that had been placed back in the 70s, where there was an out of control situation that was permitted.
And you would have no objection if there were no tent constructed in the exterior of the Valley Neck Inn, and there was no sound amplification of the music so that you couldn't hear it up on Brick Hill Road? Is that what you're saying?
I would not have an objection if there were no tent and that there were no amplified music.
Okay.
I don't think the question is whether I can hear it on Brick Hill Road. I think the question is whether the abutters can hear it, because that's where the detriment is.
Am I still on?
Yes.
I've lost the picture.
I can see you, sir. Can you hear me?
Just trying to get the picture. Yes, I can. All right, my screen has recovered. Thank you, Mr. Glory. Laura, Miss Laura, I don't know your last name, so but I'd like to, and other members of the board would like to get you as well. So if you could empower your, oh, that's it.
I'm unmuted.
Yes.
There have been so many things swirling around right now. I will say in respect and in a little bit of jest that I regret that I have not a horse nor a Harley to drive into the Barley Neck Inn and order a drink in order to celebrate the fact that I can now be subjected to amplified outdoor music up to 16 hours a week without my consent, and also nightly music up until possibly 1 a.m. I've got the bell bottoms that reflect the 70s, but I'm not sure that I can, fully go with the 70s conversion here. But
Ma'am, where do you live?
I live at 2 Beach Road. I am the most obvious neighbor that can be, which has brought me detriment in many, many ways. Just to start, my late husband and I purchased this home at 2 Beach Road in August of 2004. This is a full-time, year-round residence. My son attends Nauset school system. I'm a registered nurse at 2 local clinics here. My husband died in this house in 2013, just as many, many other people have died and been born in this house that was built in 1780, well before the Pequod started banging its drums with its uninsulated windows and doors. When we bought the house, inside entertainment under the ownership of Kathy and Joe Lewis was the norm here at the Barley Neck Inn. In the summertime, bands played nightly. Off season, it was a weekend happening, holiday weekends. Music was loud inside. It was heard very easily at our home in the wintertime with our doors closed, our windows shut until 1 a.m. when the bar closed. What often happened frequently at that time were parking lot gatherings of noisy, animated patrons who didn't want to go home at that time. We made noise complaints when the bartender did donuts in the parking lot at 3 a.m., when people continued to play music from their cars and trucks after that. We were told by police and the staff at that time that the inn was required to keep all doors and windows closed during band performances in order to keep the sound within. It's also important for me to note that at that time, per both police and the management and owners of the Barley Neck Inn, when complaints were made, that alcoholic beverages were absolutely not allowed outside of the inn. Should anyone want to go outside to have conversation or have a cigarette while the band was playing, they could not bring any alcoholic beverages outside. There was no seating outside to accommodate people who wanted to linger and drink outside. Throughout the time that we lived there, the side lawn area where live music is now played was always beautifully maintained with gardens and perennial plantings, but at no time was the lawn ever used for outside functions, with or without music. There was no meal service. There was no alcohol service. The lawn was occasionally populated with families waiting for tables for dinner in the busy summer months. The lawn expanse allowing for children to run and tumble around before their table was ready for dinner. Just prior to the pandemic, there were occasional wedding-related events that included spillover of inside guests to the lawn. With drinks in hand that were served inside, guests would congregate just outside the side door of the inn. There was still no seating. There was no outside music. There was no amplified entertainment, no bar service, and no food service. So essentially, until this unprecedented pandemic that Beverly spoke so beautifully of, and the changes that the owners just slipped inside quietly and opportunistically without permission, to suddenly be able to serve food outside, liquor outside, and hold outside amplified entertainment outside without any permission from local zoning or licensing boards. And at the time in 2020, as we all remember, being completely unaccustomed as a culture to being experienced to a pandemic and not being able to go out, this was seemed like a welcome sort of a thing. But it was indeed a completely intensified version of what the inn previously was able to do. Suddenly now we have food service outside, we have liquor service, we have outside entertainment. And the moment that this extreme, particularly in 2021, when the owners took it upon themselves to continue the amplified outdoor entertainment, the moment that it was challenged by neighbors as an intensification and a nuisance and an upset to enjoy my private property up to 4 nights a week, up to 3 hours at a time, owners and management have consistently met our concerns with aggression, excuses, and deflection. I just want to remind again, my home was built in 1780. It was a dream of my late husband and I to restore and renovate and preserve a beautiful piece of history, architectural history in this town that is often lauded for its appreciation of history. We felt fortunate to live in a historic and bucolic area that was peaceful. We were near the ocean. We had excellent schools with which to raise our son. And now, in addition, as a neighbor, because I am an obvious and not so invisible neighbor, I have been the victim of many, many threats by Facebook users who wanted to know my address. Just recently, yes.
I don't think we need any comment on that.
You don't need comment that I've been
Not on
personally
that, not on
threatened,
that,
that
not on that. No, ma'am.
Facebook users,
No,
fans
ma'am,
of
you-
the
if you
Barley
have a-
Neck Inn.
If you have a complaint to the people involved in filing that, you would make that kind of complaint. Direct-
I have made
not-
complaints
not
to
in-
the
not
Barley
in
Neck
this-
Inn.
And not in
I
this
have
public-
made
Not
complaints
in this
to
public.
the
You're not
select
gonna make it
board.
tonight, man. That is not polite or appropriate.
It's not polite that I've been threatened
No,
to have
ma'am,
a
it's not
gas
polite
powered.
that you're referring to it now. You're a
I have
dignified person and those kind of comments are not, they're not appropriate.
What kind of
Before this
comments, sir,
board.
am I allowed to provide?
You've made some good comments and we've understood your point.
Okay, so I should be as an abutter, because we are now being, Mr. Kanaga is using the status of a 1971 Pequod bar, renegade, raucous, and Josh
we-
Stewart, who lives almost 2 miles away from here, has grown up here and has learned many things, and that's the character of the town, that neighbors who live here and make their lives here can be subjected to, up to now with this new application, up to 16 hours of amplified music outside. Things have changed since 1971. My house even has insulation now that it didn't have in 1780. But that makes it okay for me, because I've been accused of buying a home across the street from a bar, that makes it okay for me to be subjected to an intensification out of their use of their license?
Everyone at this hearing on, ma'am, I think
Yes.
that concludes your remark. Everyone present at this hearing understands you quite clearly.
I'm not so sure of that, but if you say
That's-
so.
Ma'am?
Yes.
Mr. Almus, do you have any other remarks? Thank you.
Thank you, Chair. I just wanted to clarify one thing through the chair for Mr. Kanaga. Did I hear correctly that 1971, it was a special permitted use in 1971 through 1976?
Mr. Kanaga, did you make that point?
I did not.
I didn't think that was the evidence, Mr. Almus.
Okay, I just wanted to check that. Thank you.
Now, do you have anything further, Ms. Dalmas?
I do not, thank you.
Very well. Members of the board, does any member of the board wish any further inquiry of the applicant or any of the objectors? Otherwise, I'm inclined to close this hearing for the taking of evidence. Very well, I shall, Mr. Carl.
Mr. Chairman,
Yes, Mr. Carl.
may I just say that it was impossible not to be moved. Maybe this is not the appropriate place to say it, but it was impossible not to be moved by the testimony of the witnesses. I also commend the board again for the manner in which it is being conducted. And I just wanted to also point out that I believe her name was Miss Day, the first witness who has got a hand up, and I would ask that you recognize her, please.
Very well. If there's no objection by any other member of the board, will allow Ms. Day to make a further statement.
Sure. The one thing I wanted to make clear, and I don't know if it came across clearly, is that although the Barley Neck used to have late music, and that is all very true, that you could hear, and we're now saying, oh, it's less. It doesn't mean that it was allowed. It doesn't mean that it was in violation of the noise ordinances, and it was a pain to deal with. So I just want to make sure that even though we're trying to say, oh, the intensification, I just want to make sure that that's clear. Thank you.
Your point is taken, Ms. Day. Thank you.
Mr. Chairman, I saw Mr. Cole's hand up.
Mr. Cole.
So I've heard a couple references to, I think, let me back up. I think a lot of the concern was around noise. So I think in a minute, we're going to begin deliberations to determine whether or not there's been an intensification. The board finds that there hasn't been an intensification. We've overturned the building commissioner's determination. The hearing in this process ends. It goes back to the selectmen for licensing, and the beat goes on, so to speak. So before we get into that, I think the concerns have focused around the noise. I'd like to hear from the applicant on what they proposed for noise mitigation, number one, but that's really triggered by a couple comments that have been made about being in violation and or specifically violation of noise or noise ordinances. And I've read a lot of documentation that's come in on this case. I can't find, or I haven't found, and maybe I missed it, a single written violation from the police, a single fine, anything in writing that confirms a noise violation. So I just think that point should be clarified, and then back to the applicant to talk about noise mitigation, because that seems to be where the concern is focused and where the opportunity for improvement could be here.
Mr. Kanaga, then can you address yourself to Mr. Cole's questions, and specifically what efforts did you make to obtain copies of complaints made to the Orleans Police Department concerning noise, we'll say, over the past 2 years? And
Sure.
did you include in your application or supplemental materials copies of those calls from the Orleans Police Department in response to the call?
Sorry, I didn't mean to. I thought you were done. I apologize. I just used 2021 as the most recent year, but I have not. I believe it was Joe and Kathy and the previous owners back to. So we're going back to '94, and Mr. Ruggieri, to my knowledge, have never been cited with a noise ordinance violation. I don't think Yes, so no, the answer, the reason you haven't seen it, it doesn't, I don't believe it exists. I'm happy to go get the police records. I tried, what I was trying to do, and I know some of the abutters don't like my going back to 1971, that I'm not doing that because I like 1971 as a year or whatever. I'm doing it because that's the test goes to what was the pre-existing non-conforming use and when did it happen? And I tried to get police records from back then. None of them exist. I don't believe there were any police. I tried to interview police officers that may actually remember it, and I'm not sure they're around either. Chief McDonald looked into it, and I don't think we were, we didn't get anything. I didn't get anything out of the 70s for police reports either. Just they didn't exist. I did records request them, but they didn't exist. Oh, and sorry. And then the second part of Mr. Cole's question was sound mitigation. There's several sound mitigation ideas that they presented, including the what are they called? The sound barriers that Mr. James didn't particularly like. But I think if I'm hearing him right as well, it's the bass and the you know, a bass drum and amplified bass guitar, amplified bass keyboard, that could be the mitigated. If those were mitigated, those would be the longest traveling sound issues. And my client has offered that, but. So as far as sound mitigation, it's, you know, it would be, I think, to the removal of that the bass or the bass drum in the music playing. But that was one of the ideas presented. The tent, if that's an issue, we can, you know, the tent can be removed. So if we're talking about what needs to, you know, if there's a mitigation to help the abutters, that would be where they would go. And they're happy to remove the tent and have actually offered to remove bass amplification, bass in general, bass music.
Just one follow-up if I could. In one of the neighbors' letters, I read the suggestion that the music be pointed towards the boatyard exclusively. And in another writing, I read that last year the noise level was controlled by the band and that it is being proposed to now be controlled by management. Management's less likely to get excited and caught up in the moment and crank up the volume, right? So are those two mitigation efforts something that the applicant would potentially pursue?
Absolutely.
Thank you.
And I'm going to close now. I'm proposed to close the hearing for the taking of evidence. Ma'am, you spoke before. I'll let you have one sentence or two. Ma'am? Can't hear you.
Yes.
Yes, I allowed you to make a statement or two.
Yes, so after many calls to management last year when the music was overly loud,
Yeah.
and because the band was controlling the speakers, nothing had ever changed. And I had many times invited both the select board and management to come across the street to hear the volume, as it is controlled by the band at my house, and I was refused every time. So I have no faith whatsoever, as all of our complaints last year were met with rebuttals and excuses and deflection, that management is going to actually make any attempt whatsoever to reduce the noise volume as it is experienced by abutters and has been complaints. And frankly, I do not hold any confidence in the police making any kind of recommendation or opinion, considering the management and the band knew when the police were present so that they could accordingly adjust the volume to be far lower than it was during normal times.
Thank you, ma'am. Let the record, members of the board, let the record reflect that I'm examining a call from the Orleans Police Department log dated September 11th, 2021, in which the police spoke with the manager of the Valley Neck Inn, who stated that they had asked the band to keep it down and that keep the noise down, and that's while standing in the parking lot, speaking with the manager, the police officer did not detect the music to be overly loud and was unable to recognize the song being played, as the police officer could not hear it well enough. Here's an example of a complaint that completely impartial witness, police officer, who found no real the basis for complaint of noise. And in any event, the noise ordinance controls.
Mr. Chairman, I hate to do this, but that's should be given no credence whatsoever. The fact that the police heard no noise is irrelevant to whether there was or wasn't. Just discard it and let's go on. Thank you, sir.
Very well. Do you want any further evidence, Mr. Taub?
No, sir, I'm quite content with the state of the evidence.
Very well. When the hearing is closed, we're taking evidence, and I'll ask for the sense of the board. Well, I'm designating myself. Mr. Cole, Mr. Eckel, Mr. Taub, as to consider, and Mr. Mulligan to vote, and I'm also asking for the contribution of Ms. Van Giesen in the discussion. The way I see it, members of the board, is that we are empowered to determine a special permit with conditions. Findings would be necessary that the nature and purpose of the use, that is, as a restaurant and with alcohol and entertainment within and without, over, say, a 50-year period, was established by the evidence, that there was no fundamental change, or there would be no fundamental change in the proposed use by the applicant and the quality and character of the use. And finally, that we would need to determine whether there was a major difference in time and effect on the neighborhood. The zoning board is free and may attach conditions to the granting of a special permit. We may determine the history of the use starting in 1971. We also have some evidence concerning the use under a temporary permit from the Board of Selectmen, and whether it's for the purpose of the business being operated during the pandemic of over the past couple of years. The applicant suggests that the projected use would be the same under those permitted conditions by the selectmen. We are also favored by the affidavit of the penultimate owners of the Barley Neck, the Lewises, who state that they owned and operated the Valley Neck Inn from 1994 through 2015, and live amplified music was on the premises from that very time until 2015, and also refers that there was an outdoor area which was used for cocktails and gatherings, for rehearsal dinners and anniversary parties and small weddings, and that was outside. So under those circumstances, the zoning board could conclude that the proposed use is an intensification of that and determine then whether those other three conditions, which have been addressed by both council, exist. You may also determine in your findings that the evidence and the testimony has shown that the principal objections, whether by people who live 50 or 60 feet from the Valley Neck Inn, or 2,000 feet, or whether they live on the northwest in Northwest Orleans, the fact of the matter is that those objections on account of noise, which is the amplified music, would be governed and controlled by the noise ordinance, which is not the purview of the zoning board, except if you should determine that if the type of sound ought to be regulated to take into consideration the effect on the neighborhood. And members of the board, those are the considerations, the way I suggest to approach it. I'd like to hear from you. Mr. Mulligan?
Yeah, Mr. Chairman, I'm a bit confused. Before we get to the necessity of a special permit, don't we have to first find that this is an amplification and that didn't have, and that in 1971, when the zoning law was amended, this was an activity that was permitted and was allowed and was ongoing. And I think Mr. Kanaga has given a lot of evidence that through the years, this same activity occurred, sort of preserving the rights. There was an assertion tonight by the opponent's counsel that there was an abandonment, but no evidence given. So I think, don't we have to first, before we even get to a special permit, do we have to first find that they didn't have this authority, they didn't have this right, they didn't run with the land or run with the permit or run with the zoning authority as established in 1971. That was all the focus of the music and everything else in 71 is, so we've conflated our first, I think we've conflated all these noise constraints, all these noise complaints rather, with the legal rights of the inn here. And if they had a legal right going back to 1971 that hasn't been abridged, we never get to a special permit, do we?
I was going to ask the same question, the same exact question, Michael.
Very well. Mr. Todd, what is your thought?
Well, I think that we agreed at the beginning of the meeting, Mr. Chairman, that we had to make a two-part determination. And that the first part was there an intensification? And it was only if there was an intensification, if they satisfied us that there was, that we would reach the question of whether under those circumstances they were entitled to a special permit, which goes to the nature of the pre-existing special permit, because it's, as I understand special permit, after years on the board, it's the intensification of the pre-existing nonconformity. That's what the essence, if I'm incorrect on that, I would like to be corrected. So
Well,
I think that if I am correct, sir, the question before us is, was there an intensification? And if that's acceptable to you, sir, I would offer my opinion, but I would like also to hear from every other member of the board. And I've spoken a lot. And earlier, Miss Van Giesen's hand was up. I don't know for what purpose, but may we hear from each of the members of the board on that question? Was there an intensification or not?
Well, we kind of have already heard from 4. It's been bear in mind that I am the chair and I am only a facilitator. And the method of my moving this whole application forward was towards the granting or denial of a special permit with conditions. If we find that there was no intensification, then the building commissioner's referral is moot, and any relief the applicant would have to seek it some other way than from coming to us.
Isn't the relief they're seeking through the licensing process?
No, we've been ignorant of that, Mr. Mulligan, under my approach.
Well, I mean,
Mr. Cole raised this at the first hearing with the suggestion that it really belongs in licensing and not before the zoning board, which may be true. But having been here, rather than, I took this approach so that our efforts would not be moot or in vain. What would be more appropriate? So say the board may be to determine that there is no intensification, and therefore the building commissioner's referral would be overruled, and the applicant would have to obtain permission for this business model somewhere else other than the zoning board. Ms. Van Giesen, did you have a way of approaching this, or a sense that the way it ought to go down?
I think ultimately listening to the abutters and just I could feel their distress. I think that is enough for me to not be in favor of the outdoor amplified music. I think there's a couple different things too in regards to the tent. Personally, I think tents are an eyesore aesthetically. You know, you have this beautiful captain's house and this beautiful lawn. I would hate to see a tent there. But as far as the noise, you know, where I live in a residential area, and I do hear music from neighbors down the road. I hear music from Wauquoset. It doesn't bother me, but I hear the abutters loud and clear of their concerns, because they would not have a choice and it would be something on a consistent basis. Also, when you look at the neighborhood, I mean, sound travels, right? It doesn't take an engineer to know that sound travels. And so when you look at the value of homes, it affects that, because when you have people coming to purchase these homes, something that drops the value immediately is exposure to noise. So being in such close proximity to so many homes in that area, I think that's a big factor also that I would encourage the board to consider. So I know this is kind of not not along the lines of the intensification, but I felt that those points were important to consider. in the whole package here. Thank you.
Thank you. Then therefore,
I'm tempted to make a proposal, but I really want to hear from Ms. Eckholt, please.
Oh, I'm sorry. Can I add one more thing?
yes, please.
Maybe this might be something we could propose, and maybe Mr. Taub, this might be going through your mind also. Perhaps the opportunity to, just have unamplified music as a trial and see how that goes. It's much different when you have a single acoustic guitar versus a whole band or an instrument attached to an amplifier. Thank you.
And so the expert for the objectors so testified. Vice Chair Eckholt.
I think this is a two-step process. Is it an intensification? Yes or no? If no, it's not in our hands. However, I totally agree with Emily that this is not just one annoyed complainant. This is a number of abutters who had issues with it. And I really think it does have to be dealt with. And I think it is likely, as I understand it, in the licensing. And I hate to pitch it back to the select board, but I think it likely is. If we find it's not an intensification, it goes back to the select board to really deal with this issue. And it's a real issue and not just a few complainants. That's clear to me. So, but I do think it's a two-step process for us.
Very
So,
well.
Mr.
Mr.
Chairman,
Cobb?
may I make a proposal unless there's
Yes,
somebody
please.
else who wants to comment? My proposal, and I hope it's open to discussion, my proposal is that the board vote yes, that this is an intensification. There are a number of reasons I feel that's true, but the first process is that I have to ask for a second of my proposal.
Mr. Taub has, I am ruling that we will vote on Mr. Taub's motion to determine whether the proposed use is an intensification of a prior non-conforming use. There is no second on the table.
I'll offer a second motion then, Mr. Chairman.
Very
that
well.
That it is not an intensification of the use. And let me make my reasoning clear. I read with care all the submissions. I read with Mr. Tanaga's has seemed to convince me that there is a continuing chain through various owners who purchased a property, assuming that with that property came the right to provide music. And I'm also convinced that the 70s and the 71 or 76, whichever date you want to choose, I don't think it changes because the conditions at the inn didn't seem to change over that period, that it was a loud and out of control sort of situation, or maybe at least a situation that appears to be worse than it is today. And then so the property right sort of was passed on, and that was a zoning right that they got upon sort of a grandfather right when the zoning law was changed. And I think to find otherwise is to open up a slippery slope of people of other zoning instances where there are complaints about noise or pollution or something else, and we become not a zoning board enforcing the zoning code, but some sort of a societal regulator on offensive use of properties. I don't know that we're situated to do that, whether we have the capacity or the mandate. And I don't think we have to reach it in this case anyway. I mean, everybody, you can't sit here and not feel sorry for the neighbors who hear this, you know. But our issue is not noise. Our first issue is not noise, it's legal rights. And I think the owners have a legal right to continue the activity which they purchased and which they were granted in 1971 as owners and which they passed on to subsequent owners. So I'd say it's non-amplification.
I'll second the motion and immediately comment if you'll allow me to.
Yes, please.
So the matter's here before us because of the building commissioner's determination letter from February. That letter was done without the benefit of the evidence that we've heard tonight. There's a lot of information that's been presented that Tom didn't have benefit of. That letter was triggered by a request by the selectmen, which was born out of their creation of a new license. Their license didn't change our zoning. Businesses in this town need clear laws in order to operate and operate successfully. And if we are to go down a special permit path and issue a special permit, that special permit is valid indefinitely. If we determine tonight that the music and generated outdoors is consistent with the use of the property and not an intensification, the matter gets punted back to the selectmen who created this annual license. And the operator will have to operate responsibly to renew that license annually, as I understand it. But it's not, we're not a licensing body. It's not up to us. It's up to the selectmen. So again, I've seconded the motion. My opinion is, and I'll vote in favor of the motion because my opinion is that there's been sufficient testimony by both sides on the issue that noise has emanated from this property for years, for decades. And my own opinion is that bringing the music outdoors is not an intensification of that use. Our zoning bylaw does not differentiate music indoors from music outdoors. It identifies it as the same use. Thank you.
Members of the board, I concur with Messrs. Cole and Mulligan. Is there any further discussion on the motion?
Regrettably, Mr. Taub has something further to say.
Nothing regrettable at all.
Well, I'm mindful of the length of time that we've devoted to this. If I were a nastier person, I would have asked the lawyers and the experts what they were being paid for their time as opposed to what we're being paid for our time. But I'm not a nastier person, so I won't do that. I didn't get an opportunity to say why I proposed my motion in the manner that I did, but I have no objection to Mr. Mulligan's framing. It's the same question. Do we think there was an intensification or don't we? As we're discussing now, before we're voting, I want to say again, my incredible gratitude to Mr. Evers, who does his job so well. And this fell in our laps. Everybody agrees that there was a certain amount of punting here. And the reasons, and there are two main ones, that I think we should find an intensification are: one, if we don't, the owner of this property, who everybody is trying to protect in some way, or those three who have spoken so far, is intending to, no, I withdraw that characterization. I apologize. The owners of this property need relief. And maybe somebody else shoulda, coulda, woulda, but they're going to lose a season if we don't make a decision. And so I want to be mindful of the consequences of our decision and not punt our responsibility. The second thing I would say is technically speaking, I think we'll survive any kind of appeal because we're making a finding, if you will, and that's in our purview to make a finding. But I don't feel on such solid ground, frankly. If others do, that's great. But it's not the tent, it's not the this, it's not the that. I don't care about any of that, frankly. What I care about is the character of the neighborhood. And I want to get to that question. I don't want to duck it. So I would ask that the proposal of my brother Mulligan be rejected. And I would ask that people vote against it. And I would ask the chairman, in many decisions, we need 4-1. What do we need for a decision here? And there are 6 of us on the call. I'm complete.
No, I've already designated the 5 voting members. That includes you, Mr. Tom. You've heard from Ms. Van Giesen, but she will not be voting on the question. And the answer is 4-1. Mr. Eckel, do you have anything to add?
No, I'm ready to vote.
Very well. Then, and those who approve of Mr. Mulligan's motion, is seconded by Mr. Cole, will signify by voting aye. Mr. Meyer, aye. Mr. Mulligan,
Aye.
Mr. Eckel,
Aye.
Cole,
Aye.
Mr. Tom, Mr. Tom.
I apologize, nay.
Very well. Then the motion carries 4-1. I will write the opinion implementing with findings of fact established by the evidence, implementing the decision of the board and its vote. Is there anything else to further, anything else to come before this meeting?
Mr. Chairman, one quick question on process. It came up tonight in the first case. We're continuing it on for a month. It raised the issue of whether we're going to abide by the August vacation this year. I don't know if we have a discussion of that or whether we're going to continue it. I don't see the need of it. I thought last year it got us into tight corners trying to satisfy people, but that's just one man's opinion.
No, I agree with you completely, Mr. Mulligan. We'll discuss this at the next meeting, bearing in mind that my incumbency on the zoning board of appeals has extended by the last vote of the select board 3 years ago, comes to an end. This end of the fiscal year for this municipality, which is June 30th. But we can talk about who would be my successor on the board and chair, and whether there ought to be. Mr. Everett can help us out a lot there by letting us know what's in the pipeline now that COVID seems to be fizzling.
Mr. Chairman, if you would speak closer to your mic, I think it would help us all. And Mr. Evers had his hand up and Mr. Kananga had his hand up. I don't know if you want to recognize Mr. Kananga, but I'd certainly like to hear from Tom.
I don't see Mr. Kananga on the. Oh, there he, yes, Mr. Kananga.
Let's hear from Tom first, who had his hand up first, please.
Of course, I apologize. Sorry.
I
just
didn't
notice that.
I'm sorry. I was just going to say goodnight because you guys were going to discuss. You guys are going to discuss August.
Thank you.
Right, Tom.
Mr. Kananga.
Just an administrative matter, Mr. Chairman. I was wondering if you would like me to withdraw the special permit application as moot.
Before we do that, I have a procedural question.
Yes,
The motion related to intensification, do we need a motion and a vote to overturn the determination of the building commissioner?
no, I don't think so. I think it's merged inside of our, the decision will deal with that. Mr.
Thank you.
Yep.
Mr. Chairman, as always, in a challenging situation, you did a great job. Thank you. I don't know if both lawyers are on the phone, but I'm not blowing smoke. They both did a great job. And we are where we are. And we did a good job. Thank you all.
Thank you, colleagues. Any
Thank you
further
all.
comments?
Motion to adjourn.
Is there a second? By acclamation, all in favor? Aye.
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 Thank you, everyone.
Thank you.